Welcome to Concerned Citizens Presents. Concerned Citizens of Laguna Woods is an organization dedicated to peace, economic and social justice, good government, and a clean environment. Every month, we invite an expert to enlighten us on a topic related to our mission. Because Village TV videotapes these presentations, we can share that expertise with a larger audience. We hope you enjoy today's broadcast.
I will introduce our speaker in our Supreme Court, a term review, the title of which is Momentous Cases on the Culture Wars. University of California, Irvine Constitutional Law Professor Courtney Cahill is our speaker. She has an outstanding background of in comparative literature, classics, Italian literature. Why she went to law school, nobody knows except she. But she did, and it was at Yale, and she was chief essays editor of the Yale Law Journal. Her specialties as a scholar, as a teacher, as a writer are constitutional law, anti-discrimination law, reproductive rights, and gender and LGBTQ equality. After law school, she clerked for a U.S. District Court judge in Manhattan, which made our dinner table an entirely New York-based, or at least with some time in New York City table. And she was a litigation associate at a major law firm. So we have a very momentous series of cases that the Supreme Court has decided. Since the very beginning, we focused on assisting you and the community in understanding how the Supreme Court impacts our lives. This was an election year. It will again impact the Supreme Court, and the Supreme Court will impact our lives. So please welcome Courtney Cahill.
So thank you so much, Jonathan, for that warm introduction. Thank you so much for having me here. It really is a pleasure. I'm a recent transplant to California from Connecticut just 3 months ago. So you have a very beautiful place here, and I really enjoyed getting to know some of the members. So thank you for having me. So I'm going to spend most of my time with you this evening on sort of, as Jonathan said, on these sort of culture war cases from last term and from this Supreme Court term. And I'm going to spend most of my time on the two decisions that serve, as I see it, as the bookends for this talk. The Dobbs abortion decision from last term and the creative 303 free speech decision from this term. And then in between, I'm going to discuss some other big cases from this term that are on before the court this term, including some election law cases and voting rights cases and the big affirmative action cases that are currently before the court. So with that, let's start with Dobbs, right? The blockbuster abortion decision that was handed down at the end of June last year, and a leaked version of which, as you might recall, appeared in Politico in May. So the Supreme Court in Dobbs found that the federal Constitution did not confer a right to abortion under any constitutional provision and overruled two prior Supreme Court decisions that had previously ruled that abortion was a fundamental right under the federal Constitution. The first of them being Roe v. Wade, which was the 1973 Supreme Court decision that first established a right to abortion under the 14th Amendment. And then 20 years later, in 1992, there was a big case called Casey, where the court reaffirmed that abortion was a fundamental right under the 14th Amendment. So Dobbs, not only did Dobbs rule that there was no fundamental right to abortion under the Constitution, under any constitutional provision, it also overruled both Roe v. Casey on that question. So at issue in Dobbs, just for those of you, a little background of what was before the court, at issue in Dobbs was a Mississippi law that outlawed abortion after 15 weeks. The challengers, an abortion clinic and a doctor, argued that the law violated both Roe and Casey, both of which, right, both Roe and Casey made clear that the state couldn't categorically prohibit abortion before viability, right? So sometime starting somewhere around 24 weeks, right? Neither Roe nor Casey held that the state could never regulate abortion. Indeed, Casey held that the state could regulate abortion and had pretty broad leeway to regulate abortion, but they did both make clear that the state couldn't categorically prohibit or criminalize abortion prior to viability. So the doctor in the abortion clinic in Dobbs argued that because the Mississippi law criminalized the performance of abortion well before viability, right, after 15 weeks, that, look, this is a slam dunk case, it clearly violates Roe and it clearly violates Casey. So the Supreme Court granted cert, right, agreed to hear Dobbs on just the question of whether or not, so if you look at the cert petition, the question was just whether or not the Mississippi law violated Roe and Casey, right? However, in the Dobbs decision, the court went way beyond that question, asking instead whether abortion was a constitutionally protected right at all, right? And as we probably know, many of you might know by now, the court answered that question in the negative, right? That is, it determined that abortion was not a constitutionally protected right under any provision of the federal Constitution, and that Roe and Casey were wrong to say that it was. Not just wrong, but egregiously wrong, and I'll come back to that in a second. So the momentousness, to use a word that Jonathan just used, of this ruling really can't be overstated, right? And let me just provide some background or some perspective. The court rarely overrules prior decisions, right? So the court was created in 1789. I mean, it existed before 1789, but sort of was officially created through the Judiciary Act in 1789, shortly after the adoption of the Constitution. Since that time, right, since 1789, the court has handed down 25,500 decisions. Among them, only 146 overruled prior decisions. So in other words, in the court's 230-year history, it has overruled itself less than 0.5% of the time. So anytime the court overrules itself, it's a big deal. Now, what's the reason for this, right? Why does the court so rarely overrule itself? How can we explain this 146 time number? So there are many explanations for why the court so rarely overrules prior decisions, but chief among them is this doctrine or principle called stare decisis, which I love because I'm one of the few people who is a BA in Latin. And stare decisis is a Latin term which stands for, literally, to stand by things that have been decided, right? To stand by things that have been decided. So stare decisis is this idea that the court is committed to following past decisions and not overruling them, in large part because people have organized their lives in accordance with those decisions. And it would prove too destabilizing or too disruptive to just kind of overrule them willy-nilly, right? However, stare decisis is not, as the court has said, an inexorable command, right? So stare decisis, this idea that the court stands by its precedents, sometimes yields to other considerations, right? Like whether the court believes now that the decision was wrong the day it was decided, or whether the court believes that the decision remains egregiously wrong today, right? If so, right, if the court believes that a decision was egregiously wrong the day it was decided and remains egregiously wrong today, it cannot stand, right? And in the court's view, it must overrule it. So Alito said this in Dobbs of stare decisis, quote, "Precedents should be respected, but sometimes the court errs." Easy for him to say, right? Because he's overruling prior courts, not his own. But anyway, and occasionally the court issues an important decision that is egregiously wrong. When that happens, stare decisis is not a straitjacket, end quote. So thus, for example, as you might know, in Brown v. Board of Education, the Supreme Court in 1954, right, the Supreme Court found that separate but equal in public secondary schools was unconstitutional, that it violated the 14th Amendment. right? The court made that holding in Brown v. Board, even though a prior case, Plessy v. Ferguson, which was decided in 1896, had held that separate but equal was constitutional, right? So in Brown's view, the court in Plessy was egregiously wrong the day it was decided. Therefore, it was not entitled to stare decisis respect in 1954. So the $1 million, so that's easy, right? We don't respect prior decisions that we think are egregiously wrong. Right? That's the easy part. The hard part is, how do we go about determining whether or not a decision is egregiously wrong? Right? It's one thing to say, if it's egregiously wrong, we're going to get rid of it. But how do we make that determination, or I guess, how does the court make that determination? In Dobbs, the court said that Roe was egregiously wrong the day it was decided, and it's egregiously wrong today, for a few reasons, right? First, the court said that Roe's reasoning on whether a right to abortion was deeply rooted in our nation's history and tradition was flawed. Because, as the court said, abortion was criminalized in most states when at least when the 14th Amendment was adopted. So the 14th Amendment is one of the 3 Reconstruction amendments that were enacted following the Civil War, right? The other 2 being the 13th Amendment and the 15th Amendment. Right? And so what the court said is that Roe just got it totally wrong on the question of whether or not abortion was deeply rooted in our nation's history and tradition for 14th Amendment purposes, because when the 14th Amendment was passed, abortion was subject to criminal penalties in most states. Just a little bit by way of sort of background, there are some rights that are in the Constitution, right? Like the right to free speech or the free exercise of religion or the right to due process. Those are clearly fundamental rights. Like, no one disagrees that that's a fundamental right, right? The question, sort of the controversy comes into play when someone alleges that a right has been violated, but then when we open the Constitution, that right's not in it, right? So in Roe v. Wade, the argument was that Texas's criminal abortion law violated the right to abortion. Well, the problem is that the right to abortion is not in the Constitution, right? But the court has a process that it goes through when determining whether or not unenumerated rights, like the right to marry, the right to abortion, the right to contraception, are fundamental, right? And why does that matter? It matters because if the court says a right is fundamental, then if the state wants to pass a law affecting that right, burdening that right, it has a very high bar to satisfy. The state has to really justify why it needs a law that burdens a fundamental right. Does that make sense? So it really is important, right? If you want to challenge a law on the basis that it violates your fundamental right, you want to be able to convince the court that it is indeed a fundamental right, because then the state has 100% of the burden of showing why the law doesn't violate that right. Right? So in Roe, the petitioner managed to convince the court that abortion was a fundamental right, right? But in Dobbs, the court said that was wrong the day it was decided, because when the 14th Amendment was passed, abortion couldn't have been a fundamental right because abortion was subject to criminal penalty, right? So a lot of Dobbs' overruling of Roe rested on the reasoning, right, that the court used in Roe. But then the court also said that Roe and Casey, right, 20 years later, they were egregiously wrong because they articulated these, at least in the Dobbs court's view, right, they articulated these sort of ambiguous standards, right, with respect to when some abortion laws would be legal and when some would be unconstitutional. And the court said in Dobbs, that's unworkable. Right? It hasn't been workable because lower courts have been struggling to apply the law that came out of Roe and Casey, right? So I guess you could say, one possible response to that would be, let's clarify what those rules are, right? But instead the court said, we're just going to get rid of the case altogether. Was that me? No, okay, sorry, I just didn't know it was me. So in effect, what the court was saying that Roe was wrong the day it was decided. Now, it's interesting to kind of think about this. When Roe was decided, about 63% of Americans supported the right to choose, including about, I don't have the figure in front of me, darn, but including about 72% of registered Republicans. So at the time Roe was decided, there was broad Republican support. If anything, there were some Democrats who didn't support a right to choose. And then, of course, that whole story changed with the sort of Reagan Revolution and this, bringing Southern Democrats into the fold, right? But so it's interesting, right? So when Roe was decided, it's interesting to think about what makes something wrong the day it was decided. Is it wrong the day it was decided because the American public didn't agree with it? Well, that couldn't be the case because a really good, a sizable majority of Americans did support a right to choose when Roe was decided. Similarly, today, about 70% of Americans support some right to choose in some form. It's tricky because it all depends on how the question is framed and how it's asked and how it's understood. But, pollsters generally understand that about 70% of Americans disagree with Dobbs. So now it's important to keep in mind, I think, what Dobbs' holding says and what it doesn't says, right? So the court in Dobbs didn't say that abortion's illegal, right? All the court said, well, not all the court said, this was a big deal, but the court said abortion's not a fundamental constitutional right. Right? That, of course, doesn't mean that abortion cannot be protected as a matter of state law, right? So you might know that the federal constitution, in our constitutional system, the federal constitution is a floor, not a ceiling, right? So states in their state constitutions can give more constitutional protection for things than the federal constitution gives. They just can't give less. So I'll give you an example. Under the federal constitution, the court has said in a case, I think it's a 1971 case called Rodriguez, said education's not a fundamental right, right? Education's not, you won't find the word education, the right to education anywhere in the federal constitution, nor are we going to infer that one exists, right? So the court makes clear in Rodriguez that education's not a fundamental right. But under the California Constitution, as you might know, education is a fundamental right. Right? So state constitutions can give more protection than the federal constitution affords. They just can't give less, right? So after Dobbs was decided in this past election cycle in California, the voters of California, a robust majority, right? I think it was like 67% of Californians voted to enshrine both abortion and contraception in our state constitution, right? And Dobbs didn't say that California couldn't do that. Right? All Dobbs did was push it back to the states. You figure out for yourselves what you want to do with abortion, right? It was wrong for us, the federal judiciary, to meddle in that in 1973, so we're going to get out of that, right? You do what you want. And that's precisely what has happened in a post-Dobbs landscape, right? Some states, like California, have passed laws constitutionalizing abortion, and many other states, as we know, have passed laws criminalizing it. So we've got a different patchwork of constitutional possibilities now in the United States. Some of the issues that we're seeing now regarding abortion, there's so many different issues now percolating to the surface, and issues that we're seeing now and that we're likely to see in the future. One is whether someone can travel from a non-abortion state, by which I mean a state where abortion is criminalized, like Texas, to one where abortion is protected, like California, right? So like what happens if somebody travels from Texas to California to obtain an abortion, right? This was sort of what was going on, obviously, nationally before Roe v. Wade was decided, right? Shortly before Roe v. Wade was decided in 1973, New York legalized abortion, right? So people would travel to New York, right? And now there's this understanding that there would be a lot of folks, at least on this side of the United States, who are going to travel to California, right? Well, what's going to happen? Can that person, when she goes back to Texas, she be subject to criminal penalty? And in addition, right, can the doctor who performs the abortion in California and who has the license to do so in California, can he or she have their license revoked? Can they be subject to a criminal investigation by prosecutors in Texas? So there's a lot of sort of interstate travel stuff that we're going to see in the next, coming years. The other big issue, I think, is whether and how anti-abortion groups are going to mobilize now to press the Supreme Court to rule that abortion itself is unconstitutional, right? So do you see the difference, right? Like, the right to life movement's aim has always really been for the court to rule that abortion violates the Constitution because potential life, right, is potential life and has constitutional rights, right? So if the court, at some point rules that abortion is illegal, then the state's hands are tied, right? Because remember, the federal Constitution is a floor, not a ceiling. And if abortion is illegal federally, then states can't do anything about it, right? So we'll kind of see what happens there over the next few years. Okay, moving on to some of the big cases from this term. One of them is the affirmative action case, right? Which is really two cases, right? One of the cases is against Harvard, and the other case is against the University of North Carolina, Chapel Hill. In both of the cases, the plaintiffs are a group organized by a man who lives in Maine, who does a lot of these sort of finds plaintiffs to bring constitutional challenges to affirmative action cases. And he has also found plaintiffs to bring challenges to the Voting Rights Act. So he's kind of involved in this sort of multi-pronged litigation strategy against sort of race-based state action. But anyway, the group is called Students for Fair Admissions. And what that group is asking, really, is for the Supreme Court to overrule a 2003 decision called Grutter. Now, in Grutter, you might remember this case. Gosh, it's almost 20 years ago, which is amazing. I mean, I remember when this case came down. The Supreme Court held that, so the University of Michigan had law school had an affirmative action plan. And the University of Michigan's affirmative action plan, it took race into account, but not as a quota, right? Not as an automatic set-aside, right? So the law school didn't say, we're going to have X number of historically disadvantaged minorities as part of our entering class, or we're going to have 20% of our entering class at the Michigan Law School be from historically disadvantaged minority classes, right? What the University of Michigan Law School said is, we want to achieve a critical mass of diversity in the classroom, right? And we want to achieve a critical mass of diversity, including but not limited to racial diversity in the classroom, because we think, Michigan said this, diversity in all forms has benefits for everybody. So it was a kind of universalizing framing of the benefit of diversity in the university setting, right? We all need, this is what Michigan said, right? We all need to be around people from different backgrounds because we're gonna go out in the world, and the University of Michigan Law School is any blue people, big blue, yay, law school? But so they see themselves as, right, sort of educating the future leaders of the world, right? And their position was, we can't educate the future leaders of the world if they don't know about the world, right? So they have to have a better understanding of the variety of people they're gonna meet in order to succeed in a very globalized marketplace. So that's what Michigan said, right? So they said, we're not gonna achieve, we're not looking to like fill a quota. We just want to achieve sort of what we think is a kind of like tipping point, right? Enough diversity, they called it a critical mass, I call it a tipping point, right? Enough diversity to have an influence, okay? And the court agreed. The court said, that's a constitutional affirmative action program, right? So the challengers argued, that's unconstitutional, right? That's a form of race discrimination under the 14th Amendment. And the court said, well, it's a race-conscious, it's a form of race-conscious state action, but it doesn't violate the Constitution because we think diversity is a really good reason to have an affirmative action program, and we think it's, in constitutional law speak, to have a racial classification, right, it has to be narrowly tailored. Right? Like the law has to be narrowly tailored to a compelling state interest, right? And the court said, trying to achieve a kind of critical mass of diversity is narrowly tailored. A quota wouldn't be narrowly tailored, but a critical mass is narrowly tailored, so we will uphold it as constitutional. Now, it's important to keep in mind that Grutter never said, right, that states had to have affirmative action programs, right? So Grutter doesn't stand for the proposition that it would violate the Constitution for UC Irvine don't go spreading, I'm not spreading a rumor, I'm just using this as a hypothetical. If UC Irvine didn't have an affirmative action program, right, didn't take race into account, Grutter doesn't say, Irvine, you're violating the Constitution, right? All Grutter said was, if you're gonna have an affirmative action program, and it looks like the Michigan Law School's affirmative action program, that passes constitutional muster. Does that make sense, right? It wasn't saying you have to have an affirmative action program, although I will say this, there have been justices in the past who have suggested that affirmative action programs are not just constitutional, but constitutionally required to achieve racial equality, right? But that's not what Grutter said. Grutter never said affirmative action is constitutionally required. It just said it's constitutionally sound so long as it looks a certain way, right? Another thing that the court said, and O'Connor wrote this decision, right? She was sort of the great centrist on the court. She said, look, for an affirmative action program to be narrowly tailored, it had to be limited in time, right? So it has to be limited in scope, and it has to be limited in time. And she said, 25 years. Okay, we'll give you 25 years, right? And at this point, she speculated, affirmative action would no longer be necessary in a generation because socioeconomic parity would have been achieved between and among everyone, right? Sort of like 25 years, one generation, we won't need affirmative action anymore, right? Because the theory is we will have had it long enough for it to be self-perpetuating. Right? So she said 25 years. So that was 2003. So technically, FAIR for student admissions should have waited to 2028, but whatever. Right? Because we're only at 20 years, right? Okay, so back to Grutter saying you don't have to have affirmative action, right? You don't have to have affirmative action. So 3 years after Grutter was decided, the people of Michigan voted to amend their state constitution to prohibit affirmative action, right? Again, because Grutter didn't say, you have to have affirmative action. You can if you want, but the voters of Michigan said, we don't want affirmative action in our state constitution. So we're gonna make it illegal under our state constitution, which was precisely what they did. Right, so even though Grutter in 2003 allowed the law school to have an affirmative action plan, the voters of Michigan effectively overruled that decision with respect to Michigan per se, right? Incidentally, right, California did the same thing with Proposition 209, I think it was, in 1996. Right, the voters of California voted to make affirmative action, race-based admissions in university setting, unconstitutional under the California Constitution. So what do the challengers in this affirmative action case want, right? So they want the court to reverse Grutter, right? Just like Mississippi wanted the court to reverse Roe v. Wade in Dobbs, these folks want the court to reverse Grutter and hold that affirmative action violates the Constitution's prohibition on race discrimination, right? Like the challengers in Dobbs, the challengers in these affirmative action cases argue that Grutter is egregiously wrong, right? They argue that the court got it wrong in 2003 when it held that race-based admission policies were not a form of race discrimination in violation of the Constitution. So it's interesting, and we were talking at dinner about these amicus briefs that friends of the court, right, organizations can file on behalf of either side in a Supreme Court case. And I'm really interested in amicus briefs. So if you look back historically at like the big Supreme Court cases, there are hardly any amicus brief. There might be 3 or 4, right? Not many at all. But today, like in the Dobbs case, there were 231 amicus briefs. So you had 231 organizations filing. Can you imagine the clerks of the court, right? Or the justices, right? Reading all these briefs, right? So there are lots, as you can imagine, there are hundreds of briefs. I don't have the exact count, but there are a lot of briefs that different organizations have filed in this affirmative action case. And what's interesting is that Michigan, the University of Michigan and the University of California have both filed separate amicus briefs, right? And they have filed amicus briefs because they wanted to give their perspective of what higher education looks like in a world where affirmative action is banned in that state, right? So UC's position is, look, we're just going to provide the court some insight about what it means to build a diverse student body without race-based admissions. And their briefs are really, really fascinating, right? So UC says, look, after Proposition 209 was passed in 1996, racial diversity really plummeted at the UC system, especially at the highest levels at UCLA and Berkeley. They just plummeted, right? And the universities said, we don't like this, right? We are providing a world-class education, and a world-class education needs race diversity, right? So we're going to use race-neutral measures to try to achieve a racially diverse class, right? And one of those race-neutral measures is we're going to specifically look for students from lower socioeconomic, positions and recruit there. We're going to go to those schools and really try to recruit, right? To the extent that socioeconomic status tracks race, we can try to achieve some racial diversity that way, right? And another thing that the UC system did and continues to do is try to recruit from first generation college students, right? So those are race neutral, right? They make no mention of race, but they, those particular race-neutral mechanisms can have some racial impact, right? But what UC is arguing to the core, as is Michigan in their amicus briefs, is, you know what? One, these race-neutral measures cost millions and millions of dollars every year for us to implement, right? Like, I don't have the exact number, but I want to say University of Michigan's outreach programs, right, to try to achieve diversity costs the university $50 million or something like that. It's a lot of money. So it's very expensive, and it's not very effective, right? So UC laments the fact that not only is it costing us a lot of money because we can't take race into account explicitly, but it's not having the effect that we would like to produce sort of what we see as students who are really ready to go into a very globalized marketplace. So we'll see what happens in that case. Oral arguments in the case were on Halloween. And by the tenor, it seemed to me, I don't know if anybody else listened to them, there's you only need 5, right? So there's at least 5 justices, I think, who are going to vote, to reverse Grutter, right? And say that Grutter is wrong the day it was decided. Right? It's interesting, I don't want to go too far afield here, but the specific argument that the challengers are making in this case is that Grutter was wrong the day it was decided because the day Grutter was decided, Brown v. Board was the law of the land. Right? And the petitioner, and they say, because Brown was right, Grutter's wrong. Right? So there's lots, it's like very freighted, right? But like one of the things that they're doing is really establishing what some might say is a false equivalence between invidious racial classifications like Jim Crow and benign racial classifications like affirmative action. But in their view, discrimination is discrimination, right? You discriminate, it doesn't matter if you're doing it for what you think are good reasons. It's still discriminating. And that's a very specific definition of discriminating, right? It means sort of like taking something into account. What you're doing it for is it's irrelevant in their view. One last thing on this case, by overruling Grutter, right, it's not the same effect of overruling Dobbs. Right? Again, overruling Dobbs put the issue of abortion to the states, right? Overruling Grutter will take power away from the states to have affirmative action at all, right? So if the court says Grutter was wrong, affirmative action, unconstitutional, no state can have it, okay? So sort of, they cut in sort of different ways. All right, 2 other cases the court is considering this term are voting rights cases in elections. So the voting rights case. This case is called Merrill versus Milligan. a little background on this case. So after you remember the 2020 census. After the 2020 census in Alabama, Alabama created a redistricting plan for its 7 seats in the U.S. House of Representatives, right? Under the map, under the sort of redrawn map, right, post-2020, black voters have the opportunity to elect a candidate of choice in only one of the 7 districts, which is 14% of the districts, despite the fact that black voters make up, black voters, right, so individuals who can vote, make up 27% of the voting population in Alabama, right? So the redrawn map gave this population 14% of the districts, even though they have 27% of the voting power in Alabama. So registered voters and several organizations challenged the map, okay? And they argue that the state has illegally packed black voters into a single district and divided other black voters in the state of Alabama among multiple districts in ways that dilute their political power, right? So this is known as cracking voters, right? Where you divide them, right, along different, like that are completely unnatural given the sort of demographic or geography. You divide them into multiple districts to take away, to dilute their voting power. So the challengers obviously are alleging that this map violates the Voting Rights Act of 1965. So, as you might know, the Voting Rights Act of 1965, one of the biggest pieces, if not the biggest piece of civil rights legislation in this nation's history, signed into law by Lyndon B. Johnson in August of 1965. So the Voting Rights Act has a number of provisions, right? One of the provisions you might remember was called Section 5. And Section 5 of the Voting Rights Act was struck down by the Supreme Court in 2013 in a case called Shelby v. Holder. Section 5 required states with a history of racially discriminatory voting practices, required those states to get pre-clearance from the Justice Department before they changed their voting laws, right? So I'm a state that has a history of racial discrimination in voting. I want to change some of my voting laws or voting procedures. In order to do that, Section 5 said, I have to go to the federal government and it's like pre-clearance. They have to sign off on it, right? Because they want to make sure there has to be another level of surveillance or oversight to make sure that that change in procedure isn't being done in order to discriminate against racial minorities. In Shelby v. Holder, Roberts wrote this decision, the court said, we don't need Section 5 anymore. We don't need it because states are no longer discriminating against racial minorities in voting. So it's outlived its purpose, right? There's no longer any evidence of racial discrimination in voting. Justice Ginsburg, who was amazing, just like sort of my hero, in her dissent, she had this great line, something to the effect of, that's like saying, I don't need an umbrella anymore because when I had one when I went outside, my feet weren't getting wet. Right? But the court said, look, and it was the court said, look, racial discrimination is a thing of the past, right? It's that kind of invidious racial discrimination doesn't happen anymore, so these states no longer have to get pre-clearance before they change their rules, right? And it was after 2013 when all these states, therefore, started passing like voter ID laws and these sort of ballot collection laws, right, that made it harder to vote, right? Because they no longer had to go to the federal government to sign off on those procedures. So Section 5 has gone away, right? But what's at issue in this case is Section 2. In Section 2 of the Voting Rights Act, I think I have some of it. I made the mistake of grabbing my printouts too early, so I only had 24. So Jonathan put one on each table, and I just give you some of the language from some of the statutes that are issued in these cases. But Section 2 of the Voting Rights Act basically codifies the 15th Amendment. So the 15th Amendment right? Remember I talked before about the Reconstruction Amendments, right? These amendments that Congress enacts after the Civil War. There was a 13th Amendment that abolished slavery. There was the 14th Amendment that did a ton of things. And then there was the 15th Amendment that was passed in 1870 that said neither the federal government nor states could deny or abridge the right to vote on account of race, color, or previous condition of servitude. So that was passed in 1870, right? But as we know, right, states still passed discriminatory voting laws even after the 15th Amendment was passed, right? So it took 100 years, but it happened. And in 1965, I mean, kind of think about that, right? It took Congress 100 years to pass the law, right? Sort of codifying, right, the 15th Amendment. Congress passes the Voting Rights Act, Section 2 of which says, look, you can't have voting laws and voting procedures that deny or abridge the right to vote on account of race, color, or previous condition of servitude. So the challenger's argument in this case is that the redistricting map, right, to the extent that it packs black voters in a single district and cracks other black voting blocks into different districts, that's a denial of the right to vote because it's a form of vote dilution. It dilutes the vote. And the court has previously held that when states dilute the vote in this way, that's a form of denial. That's tantamount to a denial or an abridgment of the right to vote. A 3-judge district court agreed in Alabama, agreed with the challengers that the map likely violated Section 2 of the Voting Rights Act, granted a preliminary injunction, suspending and ordered the state, right? So the district court ordered the state to redraw the map. Said, you need to redraw the map in time for the 2022 midterm elections. And you have to give black voters in Alabama another district. Right? So the district court said, this violates Section 2 of the Voting Rights Act. In order to be in compliance with what the Act says, there need to be 2 districts, not just 1. Okay? What happened then, as you can imagine, Alabama petitioned the Supreme Court and said, you need to freeze the district court's injunction, right? The sort of staying of our map, the map we drew. Which the court did, right? Granted the injunction in a 5-4 decision pending a merits decision. So the merits decision is the decision that's now before the court. And it's a fascinating case. It really is a fascinating case. So, right, the argument from the challenger's position is this map that Alabama has drawn is a violation of Section 2 of the Voting Rights Act. Because, as I said, it dilutes the black vote. Alabama's defense, though, that's what's really interesting. So Alabama says a lot of things, right, in its brief, but it says, first, obviously, right, they're going to say, no, this doesn't violate Section 2 of the Voting Rights Act, right? The map that we drew is not a form of vote dilution. That's the first thing they say. And then in addition, they say, look, the map that the district court forced us to draw, adding another congressional district, that violates the federal Constitution because that map is racially discriminatory, right? Because they took race into account when drawing it in a way that violates the Equal Protection Clause. So does that make sense? So kind of what's being pitted in this case is the Voting Rights Act, which sprang from the Constitution, is being pitted against the Equal Protection Clause, which is in the Constitution, right? So in a way, I read this redistricting case as basically another version of the affirmative action case, right? They're kind of the same case, right? They're both about race. They're both about, they're both about whether or not the Constitution sees all forms of race consciousness as race discrimination. That's really, I think, what these cases come down to, right? And so the folks in Alabama, the state who wants to keep this map, right? And the folks who are challenging affirmative action, they always go back to this very famous dissent in Plessy v. Ferguson. I don't know if you remember Plessy v. Ferguson. Plessy v. Ferguson was an 1896 case where what was at issue in that case, so this is after the Civil War, right? This is after the Reconstruction Amendments, and Louisiana had a Jim Crow law that had separate railway cars for white passengers and everyone else. So if you were deemed white, right, or white enough, depending on how Louisiana defined that at the time, you could sit in the white car, everyone else has to sit in the other car, right? And it was challenged as a form of race discrimination under the Reconstruction Amendments, right? Like, we just had a war over something like Jim Crow, right? And now you're sort of reenacting it. That can't be constitutional under the Reconstruction Amendments. Anyway, the court upholds it, right, in this decision called Plessy v. Ferguson. It's an amazing decision. I mean, not for good reasons, but like, it's very short, but very rich. And there's a dissent, right? Justice Harlan dissents in Plessy v. Ferguson, right? So everyone wants to be Justice Harlan's friends today, right? Because we know now in 2022 that Justice Harlan was on the right side of history in 1896, right? And what Justice Harlan said, he said a lot of things, also a very rich dissent, but one of the things he says is, our Constitution is colorblind. It neither knows nor tolerates classes among citizens. Our Constitution is colorblind, right? And so in the affirmative action case, right, the challengers are saying, look, Harlan, he got it right. He said our Constitution is colorblind, right? That it doesn't take race into account ever for any reason, right? And the folks who are challenging the redistricting map, they're arguing that they're arguing, one, you're misreading what Harlan said, and we don't have to get into that. But then they're also arguing that clearly the Constitution is not colorblind, right? Color consciousness is baked into every aspect of our Constitution, right? It's baked into our old Constitution, the Constitution before the Civil War, and clearly it's baked into the Reconstruction Amendments, right? Because the purpose of the Reconstruction Amendments was to bring formerly disenfranchised people into, right, the community, right, as citizens, right, with all the rights incident to American citizenship, right? So their argument is, no, our Constitution's not, I don't know if you saw the oral argument in the Alabama case. Justice Jackson was amazing. She was like, wait a minute, color blindness? How can you argue that the 14th Amendment requires color blindness? The 14th Amendment was, adopted it was very attentive to race. That was its reason for being, right? So to say that we have a colorblind Constitution is to completely misread what the Reconstruction Amendments are about. So those cases are very similar to me, even though they address different issues. The other big election case, huge, oral arguments are tomorrow. This is Moore v. Harper. You should all listen, even though they're at 7 in the morning, unfortunately. Being on the West Coast, this requires us to get up a little early for the 10 o'clock oral argument at the court. But Moore v. Harper, what's at issue in Moore v. Harper is it involves a gerrymandered, let me make it as simple as possible, because it's kind of a complicated case, right? But North Carolina, which has been in the news a lot for its partisan gerrymandered maps, right, for like a decade now. The North Carolina General Assembly drew a congressional map in 2021. And a group of folks challenged the map in state court. And they argued a lot of things, but one of the things the challengers argued was, look, this map that North Carolina drew, the General Assembly drew, it's a partisan gerrymander. It's a partisan gerrymander that favors Republicans over Democrats. Now, partisan gerrymanders, right, unlike racial gerrymanders, are not unconstitutional under the federal Constitution. So the Supreme Court said, we can't weigh in on we can't even weigh in on it. It's a political question. We can't even weigh in on whether partisan gerrymanders violate the Constitution. But North Carolina has, in its constitution, it makes partisan gerrymanders illegal, right? So the challengers are arguing, look, this is a partisan gerrymander, and North Carolina Constitution prohibits partisan gerrymanders. So it goes up to the North Carolina Supreme Court, and the Supreme Court agreed that it was a partisan gerrymander, and they prohibited it from going into effect, okay? A few weeks after that, some Republican members of the General Assembly, like who created this map, challenged the North Carolina Supreme Court's decision, right, on the ground that that decision violated the federal Constitution. Okay, so you have a lot of, this is why I think this is confusing. There are a lot of different things going on here, right? You have a gerrymandered map that was challenged by people in North Carolina as a partisan gerrymander. The North Carolina Supreme Court said, yep, that's a partisan gerrymander, General Assembly, redraw it. And then the General Assembly is arguing that that order from the North Carolina Supreme Court violated the federal Constitution. So you see there's kind of different parts to this. Okay, so then the question is, why do the Republican lawmakers who are bringing this lawsuit, Moore v. Harper, which is currently before the court, oral arguments in which are tomorrow, how are they arguing that what North Carolina said is a violation of the Constitution? Well, and I put this, I think I have it in the sheet. Anyway, the Constitution, the first three articles establish federal power. Right? So you have Article 1 of the Constitution, which is the first part of the Constitution. It establishes federal congressional power. Right? So these are the folks who can be in the House of Representatives. These are the folks who can be in the Senate. These are the powers of the Senate. Right? Article 2 establishes federal executive power, presidential power. Right? And then Article 3 of the Constitution establishes federal judicial power. So the Republican lawmakers in North Carolina are arguing that the North Carolina Supreme Court violated Article 1 because in Article 1, Section 4, Clause 1 says, and it's on the sheet, that the time, places, and manner of federal elections is determined by the state legislature. Right, the state legislature, unless the federal Congress intervenes, right? So what the Republican lawmakers in Moore v. Harper are arguing is that only the state legislature can control federal elections, right? Including drawing maps, right? So only state legislatures can pass laws dealing with federal election, the time, place, and manner of federal election. And congressional maps fall under that, right? So their argument is that the North Carolina Supreme Court has no power to determine what the map is going to, can and cannot look like, even though under the North Carolina Constitution itself prohibits partisan gerrymanders, right? The argument is, doesn't matter, because if the state legislature wants to draw the map this way, it has plenary or exclusive power to do so according to Article 1. It will be a very interesting, this is huge, right? It sounds very arcane, and this is known as the state independent legislature theory, or the state independent legislature doctrine, right? And the doctrine says that only state legislatures, right, not state courts, not nonpartisan election commissions like we have in California, only state legislatures can kind of control federal elections in that state when they happen, right? State courts can't intervene, right? Not even state actors can intervene, right? Like the Secretary of State or whatever. If there's an election emergency, they can't intervene. It's only the General Assembly, right? So this is a big deal because people are worried, right? Well, one, they think, right, that's wrong on the interpretation of the Constitution. But if the court buys it, there's a concern that if the court says that only the state interprets the federal constitution, the word legislature, to just mean the General Assembly, then what's going to happen with electors during a presidential election, right? Because in Article 2 of the Constitution, which deals with electors, right, it says state legislatures send electors, right, choose the electors. Right? Well, now we understand that clearly to mean the people in that state. We choose the electors of our state, not our legislatures, right? Our politicians don't choose the electors in California. The people choose the electors. But since the same language appears in Article 2 as it appears in Article 1, if the court interprets in Moore v. Harper Article 1 in this particular way, there's grave concern that it's then going to interpret that same provision in Article 2 the same way during a presidential election, right? Overriding, as we saw in the last election, which obviously didn't happen, but it could successfully happen if the court signs on to this sort of independent state legislature idea. So I think it'll be a very interesting argument. There's going to be a lot of kind of history, text and history, right? Like, what did the framers mean when they used the word legislature in that amendment? In Article 1 and in Article 2, right? Does legislature just mean the state political body, right? Or does it also mean state courts and whatnot? So oral argument tomorrow at 7. Okay, the last case that I'm going to talk about is one called Creative 303. And there were oral arguments in Creative 303 yesterday. Did anyone happen to hear them? I know Jonathan heard them. Okay, so Creative 303 is a case, it's a lawsuit between a woman named Lori Smith, and Lori Smith is from Littleton, Colorado. So it's a lawsuit between her and the folks in Colorado who are charged with enforcing Colorado's anti-discrimination law. So not all states, I think I want to say only 21 states have anti-discrimination laws that prohibit businesses from discriminating on the basis of sexual orientation, right? So these are known as public accommodations laws. Every state has a public accommodation law that says if you're a business, you cannot discriminate on the basis of race. Right? Every state has a public accommodation statute that says if you're a business, you can't discriminate on the basis of sex. But only 21 states have a law that says if you're a business, you cannot discriminate on the basis of sexual orientation. Right? So you can't turn away a gay customer simply because he or she is gay. Colorado is one of those states. So Colorado actually is like a really fascinating state because on the one hand, Colorado has very broad anti-discrimination protections for sexual orientation. It has a history of that. It was kind of a first mover for sexual orientation protection under the law. But Colorado also has, a sizable population of folks who want to push back on those anti-discrimination protections for religious reasons. So there's been a lot of conflict in Colorado over the last 2 decades, right? I don't know, when I was growing up, Colorado, I think about Colorado as a red state, and then at some point it became purple, and now it's blue. It kind of has this very, push and pull history. So it's a lawsuit between her and the folks who are in charge of enforcing this anti-discrimination law. In a nutshell, Lori Smith is a website designer, and she wants to expand her business, and she wants to get into the wedding website space, right? And she's worried that if she opens wedding websites, she's going to have to serve same-sex couples, right? So if same-sex couples come to her and say, look, we're getting married, we want you to make us a website, she wants to be able to turn them away. Right? Because of her, in her words, she has a deeply held religious conviction against same-sex marriage. And by making the website, she's sort of putting, I think she actually makes this argument, she says, I'm putting my imprimatur on that relationship, right? I'm putting my imprimatur on that relationship. So nothing has happened yet, right? She hasn't even opened up her business. But so this is called a pre-enforcement challenge, right? So her pre-enforcement challenge is this: to apply the anti-discrimination law to her, if that's what Colorado decides to do when she finally opens up the business, has a gay customer, and turns that couple away, right? Her argument is that violates, to force me to serve people I don't want to serve, that violates my First Amendment right, right? I have a First Amendment right to exclude, right? I have a First Amendment right to exclude, and this law that requires me to serve, that requires me to include, violates that right. Now, let's be clear, this is not foreign territory, right? Like, these arguments have been made successfully to the court for decades. I don't know if any of you remember the Boy Scouts case from 2000. So there was a really big case called Dale v. Boy Scouts of America. And in Dale, what happened in Dale was this guy, he was a scoutmaster, this exemplary scoutmaster, right? And at the Boy Scouts, he went through, he was a Eagle Scout, right? And then he goes to college, he goes to Rutgers. And he's a scoutmaster, he remains a scoutmaster. While he's at Rutgers, he comes out, right? And there's an article that the school newspaper does on him. And he comes out, and in part of the article, he talks about how it's important for young kids to have gay role models, right? Like, he didn't want to be in the closet. He wanted to show young people that, you can be out with your sexual orientation and still have acceptance and all of that. So this is all in the newspaper. In New Jersey. This is all happening in New Jersey. The Boy Scouts, the local Boy Scouts, troop, finds out about this, right? And they tell the National Boy Scouts, and they're like, oh yeah, this is a problem. This is a problem, right? Dale is not just, he's a scout master, and he came out as gay in his school's newspaper. And in their view, homosexuality was inconsistent with the Boy Scouts' message, right? So they expel him, right? And he argues, he brings a lawsuit in New Jersey, it goes up to the New Jersey Supreme Court. And he argues, so, New Jersey, like Colorado, has a tradition of having broad anti-discrimination protections. So New Jersey has a law that says if you're a place of public accommodation, you can't discriminate on the basis of sexual orientation. And Dale's argument was, look, the BSA is a big organization, right? It's a place of public accommodation, and it's discriminating on the basis of sexual orientation. You've violated the law. And the New Jersey Supreme Court agrees and says you got to get this guy back in, right? They then bring a case to the Supreme Court of the United States. And their argument is, when New Jersey Supreme Court effectively forced the Boy Scouts to take him back in, they violated the First Amendment rights of the Boy Scouts, right? And in that, the First Amendment says a lot of things, right? So the First Amendment protects free speech. The First Amendment protects free exercise of religion. It protects petition. It protects assembly. It prohibits the establishment of religion. Impliedly, in all of that, is a right to associate, right? Like, you can't have religion without association. I mean, I guess you can, but it helps to have association. You can't have petition without association, right? So the court has recognized for a long time an implied right of association, right? People can associate with each other without being sort of punished by the state. And Boy Scouts argued, this is compelled association. You're forcing us to associate with somebody we don't want to associate with. And they won, right? It was a 5-4 decision, and they won. And this was more than 2 decades ago now. So this woman's claim is not coming out of nowhere, right? There is actually very strong precedent for it. But the key difference here is this. The Supreme Court has ruled in favor of the First Amendment rights of organizations to exclude gay people, but it has never, in its 230-year history, ruled that businesses have a right to discriminate, right? That never has the Supreme Court said that someone in the stream of commerce can use the First Amendment as a trump, right? It has never said that First Amendment rights in the marketplace are elevated above and beyond other equality rights, right? Because let's face it, the Boy Scout, maybe it has commercial aspects. It's not really commerce, right? And what she's arguing is that you don't leave your First Amendment rights at the door when you open your door for business, right? So that's really what the court has to decide in this case, right? Whether or not, specifically she's arguing I'm an artist, and this is compelled artistic speech, right? And that compelled artistic speech is different from, like some people are worried, if the court rules in her favor, what's to stop McDonald's from saying, we're not going to cater the birthday party of a same-sex couple because, we don't want, it's sort of compelling us to associate with, an ideology, a lifestyle, whatever you want to call it, that we disagree with, right? Now, some might say, well, there's a difference between the website designer and McDonald's. McDonald's isn't artistic. But the thing is, when it comes to free speech, the court has made more than clear whether something's art is in the eye of the beholder. The court has always deferred to the artist when determining, or the person when determining whether or not what they're creating is art, right? It's kind of like religion, right? The court's not in the business of saying, that's not a real religion, we're not going to protect it, right? So my concern is that, her lawyers are trying to limit this case to artistic speech, but artistic speech can't be limited. It can't be cabined in that way. It's impossible, right? The maybe not McDonald's, but a smaller mom and pop store might say, look, we put a lot of time and effort into our catering. We make it just so, right? We make it nice. There is an element of artifice there. And so we should be able to have a First Amendment right to exclude. One last thing on this case is, I don't know, if you heard oral arguments, you should go back and listen because they were really, really fascinating. But Justice Jackson pressed her lawyer throughout oral argument. Justice Jackson says, look, I'm going to give you a hypothetical. There are lots of hypotheticals in the oral argument. It is law after all, right? And she said, here's my hypothetical. Family goes into a mall, and there's a photographer at the mall, and there's a Santa, right? And there's a Santa there. He's white. And they're selling, like, the product is, have your picture taken with Santa and recreate the 1950s, Christmas from the 1950s, right? And there's like Justice Jackson said, I'm thinking It's a Wonderful Life kind of thing. Like, that's what the photographer is trying to create, right? And a black family goes in and says, oh, we want to have our picture taken with this It's a Wonderful Life. It's our favorite movie. We want this. And the photographer says, no. Because what I'm trying to do is create a particular feeling, and this would cut against that, right? And the lawyer, so Jackson asks her this question throughout the entire oral, like, she's not going to let her off the hook. And the first time she asks the question, I think she completely dodges it. Oh, not relevant. Yeah, that's what she says. She's like, well, that's race and this is sexual orientation, so they're different. Let's move on. And then Jackson's like, yeah, but no, they're not different. And in addition, if we rule for the artist here, wouldn't that set a precedent for a photographer, in my hypothetical example, excluding the black family? Right? And then the lawyer says, well, she calls it an edge case. And then Kagan comes in and says, yeah, so which side do you fall on that edge? She still doesn't answer it. because what happens at that point, it's like an amazing oral argument. At that point, the other justices sort of come to the lawyer's rescue. And they're like, oh, but wait a minute, there's a difference between race and sexual orientation. And then Jackson, not satisfied, it's almost over, the argument, right? She says at the very end, look, could you just give me an answer here? I'm just dying for the answer. And the lawyer says, look, when it's a kind of battle between liberty right to free speech and equality, liberty should win. So she basically answered, yeah, I mean, this could set a precedent for allowing people in the marketplace, like the hypothetical photographer, from excluding individuals on the basis of race, right? Anyway, so that was that case. And I am done, but would love to hear any questions. Oh, for oral argument, it's supremecourt.gov. Right, and there are past oral arguments there too. So you can hear this Creative 303 oral argument, which really was super fascinating. So, thank you. Yeah.
If you have any questions, raise your hand.
Yeah.
I'm wondering if there's any redress about Supreme Court justices when they are being interviewed lying under oath. Is there any redress on that?
No. The question was, is there any redress for Supreme Court justices lying under oath? I mean, I'd have to go back, and maybe you have, and listen to Justice Barrett's confirmation, right, and I've pored over, she has written on stare decisis and precedent, and when it should be respected and when it should not be respected. And honestly, I think she wanted to become a Supreme Court justice. And evidently, I don't, because in my writings, I'm very clear, what I think is the case. But in hers, it's not clear. Like, her stuff on precedent is like, you read it and you're like, I just don't understand. Like, it doesn't really come down on a position either way, right? She sort of hedges, and I feel like, if I remember correctly, she kind of did that at her confirmation, right? Like, she left enough wiggle room. Yeah. Well, right, Senator Collins from Maine, right, tried to, Justice Kavanaugh was like, you lied to me, right? Because I asked you in our office interview whether or not you supported Roe v. Wade, and you said you supported precedent, so. I mean, but I guess they could change their mind. I mean, I don't know, yeah.
The press reported some bizarre comments from Justice Alito. Are you comfortable talking about that?
Yeah. So Justice Alito at one point, one of the questions he asked, I guess was it the Assistant Solicitor General maybe? I can't remember who the question was, but who it was directed toward. But right, he said, well, like look, if there were a black Santa down the hall or on the other side of the mall from the white Santa, and the black Santa didn't want to sit with children dressed in KKK uniforms, do you want to be able to force, shouldn't he be able to reject the kids in the KKK uniforms? Like, his point was, look, this kind of, I think his point is this works both ways, right? Progressives should like a decision in favor of the artist, because progressives don't want to have to serve people that they find reprehensible, right? Does that, right? And so the answer, which was the right answer, was, but public accommodation statutes don't protect people dressed in KKK uniforms, right? Like, so part of it was the scope of these anti-discrimination laws. Anti-discrimination laws pick and choose. They don't protect everybody. They don't protect people from the KKK, right? So, like, they can be discriminated against, right? Unless they can argue it's a form of race or sexual orientation, right? So the hypothetical Black Santa can already turn those folks away because those folks aren't protected under anti